Hi everyone and welcome to my channel. My name is Diana Romanovska and I am a certified family law specialist practicing family law in the Bay Area. Today I would like to talk about date of evaluation of community property during the divorce proceeding. Is it date of separation or is it the date of trial? Well, it depends. Family Code section 2552A states that it has to be as near as possible to the time of trial. And in section B, it says the court has a discretion for good cause to determine any day after date of separation and before the date of trial. So the ground rule is the date of trial, exception somewhere in between. And I'm going to list a lot of case law that defines in what case what will happen. First of all, what is trial? Sometimes cases don't go to trial. Trial is defined when property is actually divided. It could be marital settlement agreement. It could be right before that when party evaluate a house or stock or any asset. If parties bifurcate marital status only, they say, here in part 1, we're declaring ourselves single after 6 months and 1 day after respondent received the moving papers, petition, and summons. And part 2, we reserve the jurisdiction over all other issues. Well, in that case, the division of assets is going to happen the closest date to the trial. So the court tends to go towards the latest possible, not date of separation, the latest possible date of evaluation of property. In Marriage of Olson in 1980, the court defined the sentence of as near as possible to the date of trial in the case where the trial happened and then the house got foreclosed before the judgment was entered. The court allowed to reopen the case and evaluate the asset as it was at the date of trial, not after trial. So the exception is when intervening event or sale happens, then the property can be evaluated after trial. In Johnson case, 3 years later in 1983, a boat was evaluated at $90,000 and sold at the trial and sold before a judgment was entered at $140,000. And Johnson case is case of appeal, which means it went to Court of Appeal to whoever was not benefiting from $140,000, asked the court to reevaluate the asset and divide it as of $140,000 and split $140,000. The court said yes, because intervening event happened, sale or foreclosure or forfeiture, any type of event that happens after the trial or before a judgment is entered triggers reevaluation. So if an asset goes in value before a judgment is entered, watch out. Do not sell, wait until the judgment is completed so that it doesn't trigger reopening of the case. It doesn't work if parties stipulate it to a value. So it only goes when it happened at the trial. In Connolly's case in 1979, as a contrast to 2 other cases I mentioned, there was evaluation of stocks at the time of trial. Then there was a judgment, and a month after the judgment, the stocks went in value 4 times. And in this case, the court did not reopen it because the judgment was entered. Case of appeal, California case of appeal Campi from 2013 states that this code section 2552 does not prevent parties from stipulating to a date of evaluation of community assets. And if they do so, it doesn't matter about the trial, it doesn't matter about the judgments, nothing matters. They have to stick to the date they stipulated to evaluate a particular asset. Let's talk about Section B, 2552B. It states that upon 30-day notice to the other party and the court, the court can decide on evaluation date somewhere for good cause, somewhere between date of separation or after date of separation and before judgment. So we have first notice, 30 days. How do we give notice? It's a FL Form 315, California Rule of Court 5.390, and that notice has to come with a declaration and explanation for a reason. What's the reason for good cause? Evaluating it prior to trial. So the default is trial. Why is it prior to trial? And the court has discretion to say, yes, it makes sense to evaluate it prior to trial. In what case, for example, would it make sense to evaluate an asset prior to trial? And in Stevenson case in 1993, and in Nelson case, court decided that in small businesses, when the increase in value of the business is primarily depending on the personal skill, knowledge of industry of the person who runs the business, let's say it's another spouse, then why should and we know that after the date of separation, everything that one party earns is their separate property. So why should the other spouse participate in increase in value of that property if it's separate property anyway? The income from the business. So in those cases, the court agrees that the date of separation or any time after date of separation before trial isn't appropriate. Again, the opposite case where it's both market conditions plus personal skills. For example, someone is running a business in trading and it's both personal skills, but also a lot depends on market conditions. Then the court doesn't, and it was Imperato case from 1975. It wasn't about market condition. It wasn't about trading. However, I'm just giving an example when it can be both. If it's both, then the court held that the date of evaluation should be the date of trial. And of course, if it's only market condition, business is dependent on market conditions, then the date of evaluation of such business is the date of trial. I hope that was helpful. If you have any questions, comment down below. If you like the video, click like and subscribe. I will see you soon. Bye!